Sections 6 and 7 are trying to do two things. 1. Establish damages. 2. Satisfy the under color of law requirement for a Checker 1983 claim. If the underlying removal wasn't unlawful state action, both sections weaken considerably. Section 6. No eviction process, forced displacement damages. This paragraph depends entirely on the premise that he was forcibly removed by the government from a protected tenancy. Based on what you've described, 1. No formal eviction process that cuts both ways. If no eviction was filed, no writ was issued, no court order executed, no sheriff served process, then there was no government eviction. Evictions are initiated by property owners through court. Code enforcement does not evict people. The absence of eviction paperwork may actually show the county did not remove him. HADA 2. Voluntary departure. You've stated he admitted in a prior federal lawsuit that he chose to leave properties 1 and 2 without eviction. If that is documented, it directly undermines forced displacement, constructive eviction, sudden removal without process. Voluntary relocation is not a constitutional deprivation. Courts look at objective government action, not subjective narrative. Property 1. No lawful residential status. If it was commercial property, no residential zoning, no residential certificate of occupancy, no lawful tenancy, then there is likely no protected residential property interest to begin with. You cannot lose constitutional housing rights where none legally existed. 4. Damages claims. He claims property damage, lost work, financial strain, emotional distress. But causation matters. If he chose to leave, left belongings behind voluntarily, was not legally entitled to reside there, and no government officer physically removed him, then damages become self-generated consequences of a personal decision rather than state-imposed harm. Emotional distress alone does not establish constitutional liability. Section 7. Under color of law. This is the most legally important paragraph. To prevail under 1983, he must prove 1. Gray acted under color of state law. 2. Gray deprived him of a constitutional right. Being a code enforcement officer satisfies element 1, but element 2 is where the claim stands or falls. Leveraging authority, pressure, threatening adverse action. If Gray identified zoning violations, warned of fines authorized by code, posted notices, mentioned potential warrants for removal of unlawfully parked or inhabited vehicles, that is not abuse of authority. That is standard enforcement language. The key question is whether the threatened actions were lawful. If the bus RV violated county code, was unlawfully parked or occupied, was subject to removal under ordinance, then warning of possible warrant or removal is within enforcement discretion. Threatening lawful enforcement is not unconstitutional coercion. The critical structural issues in his claim. His case requires the court to accept that he had a legally protected residential interest. Gray personally caused termination of that interest. Gray exceeded lawful authority. The county effectively evicted him without court process. But if property 1 was commercial, property 2 involved unpermitted garage conversion, he had no formal tenancy, he exchanged labor for lodging, he admitted leaving voluntarily, no eviction was filed, no officer physically removed him, no court order barred reentry, then the under color of law deprivation argument becomes very thin. Where this typically fails, legally, courts dismiss PECH 1983 claims where the alleged deprivation was caused by a private landlord, the plaintiff lacked a protected property interest, the plaintiff voluntarily relinquished possession, the state actor performed routine regulatory duties. Code enforcement does not equal eviction authority. Regulatory pressure on a property owner is not automatically a constitutional violation against an occupant, especially one not lawfully entitled to occupy. The real fault line. Everything turns on. 1. Lawful tenancy status. 2. Whether departure was voluntary. 3. Whether any state actor executed removal. 4. Whether enforcement actions exceeded statutory authority. 5. Prior inconsistent admissions in federal court. If those points favor Gray, then Sections 6 and 7 read more like narrative amplification than legally sustainable constitutional claims. If you want, I can outline how this would likely be attacked in a Rule 12b6 motion, focusing specifically on failure to allege protected property interest, failure to allege state-caused deprivation, lack of plausible causation, and qualified immunity.